afternoon, everyone. My name is Sharon Hecker, and I'm the chair of ICRA, the International Catalogue Raisonné Association. I wanted to welcome everyone, also on behalf of our wonderful board, Matthew Stevenson, Alex Morrison, Sarah Davis, Lisa Lefebvre, and Michelle Shuttleworth, to this ICRA Spotlight. This time, it will be dedicated to a very thorny legal issue. Its title is Curatorial, Digital, and Legal Perspectives on Catalogue Raisonnés and Spoliated Art, an Open Question. Although there is a great interest in this question of spoliated art, we really wanted to approach it from the direction of cataloging, which is where our membership is most interested. Today, we have about 120 people registered for this Zoom, which suggests that we've hit on a very important topic. And one of my goals as chair has been to connect the world of art historians, curators, and those engaged in catalogue raisonnés with the legal world. I think that these intersections between our different yet interconnected areas of work and greater dialogue can be mutually beneficial and actually can help shape new directions and thinking in our respective fields. Today, we have an amazing lineup of speakers who will be introduced in a moment, but I did wish to thank our esteemed panel and for accepting our invitation to speak to us today from different viewpoints. I also wanted to mention that ICRA's 7th annual conference will be soon announced on our website, so keep checking. Events like these, as well as this spotlight, help us to support the high quality of content that ICRA is now well known for. Our past conferences are now all available on YouTube via our website. Please consider becoming a member of ICRA. We're a nonprofit membership-based association that brings together people involved in catalogue raisonné work, as well as people who engage with making and using this tool. We depend on our membership for support, and you can contact the wonderful Emily Gasparo for more information. Today's moderator for the panel will be our board member, Frances Fowle. Frances is Emeritus Professor of 19th Century Art at the University of Edinburgh. In parallel with her academic career, she was for 25 years the Provenance curator and then senior curator of French art at the National Galleries of Scotland, where she co-authored the critical catalogue of French paintings, which was published in 2022. She's an expert on Impressionism, collecting, and the art market, and has spoken about the subject on radio, film, and television. She's curated numerous international exhibitions, and her publications include Van Gogh's Twin, The Scottish Art Dealer, Alexander Reed, Globalizing Impressionism, and the Art Market and the Museum. Just a few last housekeeping notes. We've gathered questions that you have sent us in advance, and we will try to answer as many as we can during the session. You will all be muted, but you can write things in the chat. We can't promise to get to everything in the chat, but we will try our best. And just to let you know, this event is being recorded and will eventually be made available online through our ICRA YouTube channel. So I will, with very great pleasure, pass it on to Frances.
Great, thank you, Sharon. And yes, welcome once again to our 3 speakers. I'm going to give very brief introductions, and then I'm going to ask them to introduce themselves. So I'm just going to start by briefly introducing Victoria Reed, who is the Sadler Senior Curator for Provenance at the Museum of Fine Arts in Boston. So Tori is responsible for the research and documentation of the ownership history of the MFA's collection. And as a result, she's overseen a large number of restitution claims. She's also lectured and published extensively on provenance research, museum ethics, and art restitution. She earned her BA in liberal arts at Sarah Lawrence College and her MA and PhD in art history at Rutgers University. Welcome, Tori. And the next speaker is going to be Nicholas O'Donnell, who is a partner and art and museum law practice leader at Sullivan Worcester. He's a specialist in cultural property and the author of A Tragic Fate, Law and Ethics in the Battle over Nazi Looted Art. He has served as lead counsel on a variety of lawsuits concerning restitution and fine art sales, and he's advised museums, dealers, auction houses, and collectors worldwide about restitution, copyright, and deaccessioning issues, including an argument before the Supreme Court of the United States in 2020. And in addition to his book, he's an author of numerous articles and papers on the subject of art disputes and regulation. So we're looking forward to an exciting contribution from him too. Thanks, Nick. And then finally, last but not least, we have Kate Fitz Gibbon, who is at Santa Fe, New Mexico attorney for art and estate planning, and the editor of Who Owns the Past: Cultural Policy, Cultural Property and the Law. And she's also the editor of culturalpropertynews.org, which is an online newzine, like that's a new expression for me, that newzine, on art, policy and heritage, and the author of 5 books on Central Asian textiles. She's also mentioned a specialist in Central Asian art law and the author of Native American Art and the Law, and I hope she's going to talk a little bit about that today. So welcome all 3 of you, and I'd like to kick off with Tori. Can you now expand a little bit on what you do, and speak about your work as a curator and your experience and areas of specialism, and whether you or the extent to which you use catalogue raisonné in your work.
I'd be happy to, and thank you so much, Frances, and to Sharon for introducing me, but also for bringing me on stage. It's nice to be here. So I am at the Museum of Fine Arts in Boston, and for many years now, my title has been curator for Provenance. I'm pleased to say that Provenance is now its own department here, actually. As of July 1st, I will be chairing that department. So we are a small but mighty cog in the wheel here. So Provenance has really expanded here and expanded its scope, and it's really grown. I started here in 2003 as a Nazi-era provenance researcher. I started working in the Art of Europe department, and pretty quickly sort of learned by doing, working through some restitution claims. But the longer I was here, the more provenance became important, not just for Nazi-era claims, but really throughout the whole curatorial division. And in 2006, the MFA repatriated 13 antiquities to Italy, for example. I was not involved at that time, but it sort of speaks to how cultural heritage issues were really growing and how museums needed to pay attention to different aspects of their collection. I think for a long time, people thought provenance was just Nazi looted art, and that's clearly not the case. So in 2010, my job here expanded, and I became the curator for Provenance, working under our then deputy director, with each curatorial department. Sorry, I seem to be losing my voice. With each curatorial department looking not just at claims, not just at the existing collection, but potential acquisitions and potential loans. Because what we don't want is to bring more objects into the collection that may be claimed in the future. And so what we have really tried to do is standardize the due diligence process here, to ask the same questions for every potential acquisition, for every potential loan. And of course, there are differences, but we want to make sure that we are being consistent. And so now, the issues that may come up are not just Holocaust era, Nazi era, but archaeological looting and today, the legacy of colonial era looting. So it really is a division-wide subject, and I think one that our audiences are particularly engaged in. They want to know more, and I do think that they hold museums accountable in ways that perhaps the public isn't used to. In terms of catalogues, yes, of course, particularly for paintings and sculptures, we use catalogues raisonné. We have a large collection of Impressionist paintings here, so we rely on the Van Gogh catalogue raisonné, the Monet catalogue raisonné. Particularly, we have several versions of of Monet paintings, several versions of the same subject of Van Gogh paintings. So in cases like that, relying on catalogues raisonné is critical. You want to figure out which version has been where, who has owned it, where it's been exhibited, and all of that. But I think my own personal experience with cataloging has more to do with the cataloging that I do for the MFA for compiling information for our collections database that then goes to the web. And in particular, I work on our provenance records. So we have we have over 500,000 objects in the collection. I've worked on probably just a tiny fraction of those. But again, the job is consistency. We want to have a consistent provenance format, consistent standards so that our records are not just accurate, but also understandable. In terms of the subject at hand today, one thing that we have tried to do here at the MFA is keep our restituted objects online. So in other words, when we deaccession a work of art for repatriation or for return to a family of Holocaust victims, we don't delete the record. We feel it's important to keep that online, to keep the provenance information online, and to keep that cataloging information present for people who might need it. So I think my experience with cataloging is maybe from a different end of things. Yes, of course, we use catalogs, but also I do a lot of compiling and presenting information for the museum.
Thanks. Yeah, that's. I mean, I have the same experience as a curator that we seem to do more cataloging than. But obviously, you use the catalogue raisonné when you're doing the cataloging. But it depends. I noticed that it was interesting. You mentioned impressionist. So for impressionist art, it's very useful. There's maybe an area which is more useful than other areas. Is that the case?
I think so. I mean, when you think about how many, just for example, how many haystacks did Monet paint? Right now we have the Van Gogh Roulin show here at the MFA, and sometimes Van Gogh painted the same subject, the same person over and over again. So what's really useful is someone has laid some of that basic groundwork and figured out which version is which. So that can be really helpful. And you want to make sure, has the provenance of our painting been confused with another one, which happens.
And then you're hopefully then going to be adding to the future catalogue raisonné, or once because the problem is
so it's a back and forth now, and many catalogues raisonné I think are becoming digital. So yes, so we both use them and then conduct our own research and then are able to offer that information back to the authors of the catalogue raisonné.
Yeah, perfect. Okay, thank you very much. So I'll pass on to Nick now. Could you tell me a bit more about yourself and how your work connects?
Sure. And thank you also for having me, to everyone. This is really exciting. So just to sort of set the stage, I remember learning what a catalogue raisonné is when I was an undergraduate art history student, and I sort of couldn't scarcely believe how wonderful a thing this is. I thought just sort of the idea that there are such projects is so great. Now, I am now a lawyer, and I have been in restitution-related advice and litigation for 15 plus years, in addition to my general practice. And so I wanted to talk about a little bit was sort of how that kind of information fits into what I do. I am advising people typically on either bringing a claim, most frequently in my practice in that case, for claimants who are the survivors, but increasingly more the heirs and descendants of victims of Nazi-era spoliation, or I'm advising museums and collectors who own paintings against which a claim has been made. And to advise my clients, I have to look at a lot of different kinds of information. I was at Christie's a couple months ago. We were talking about databases and how they have evolved. Before I was a lawyer, I worked at the Clark Art Institute in Williamstown, which has obviously cast a long shadow on my career. And it's funny you mentioned, Tori, sort of the narrowing down things. One of the objects I looked into in the 90s when the first task force guidance came out was a Rubens painting that the Clark has that had been that echoes of which appeared in a looting report, which turned out was not the same painting. And it sort of took a lot of legwork and exhibition catalogs and sort of triangulating different kinds of effects to determine that the looted painting was a finished Rubens, which is 9 feet tall, and the Clark painting is a sketch that you can hold in your hand. They're different objects. It's clearly the case, but it took all that kind of gumshoe work. And so for me, a catalogue raisonné is not so much definitive evidence of anything, but it's a certain kind of evidence that's very useful. Evidence it's important to remember is itself kind of a reliability spectrum. You hear a lot about what's admissible or hearsay and that kinds of things, but as my favorite Simpsons character Lionel Hutz says, hearsay is a kind of evidence. Hearsay is not useless, it's just not admissible in court, but it can lead you to learn other things. And so in the Nazi era realm, to try to sort of be efficient until we get to questions, there are lots of different kinds of documents and sources, but a lot of them are pieces of paper that are very hard to make heads or tails of, or to know how to proceed from. It may be an inventory, which lists a painting. It may be a letter, which talks about the collection of a certain person that moved from place to place. And I think the role that the catalogue raisonné plays in the best circumstance is because it has a certain high level of scholarship, it really allows you to pinpoint objects in time and space relative to the people who have them and who are showing them, how they exhibit them. Again, you're not always going to know from that, but you see collections that are exhibited. Often you see collections that aren't, and that helps you keep track of things as they come in and out of public view. And I think that's very important, particularly with the passage of time, because these other kinds of documents, which again, in their legal sense, are hearsay. So if there's a letter from somebody in 1942 that says, I have had to relinquish my painting because the Nazis came to my door, that's pretty compelling information to you or me, and it's almost certainly inadmissible in court, because there isn't a human being who can stand on the witness stand and say, I received this letter, or I wrote this letter, so it is what it appears to be, and here's why this out-of-court statement should be admitted in court. So that's a lot of wrangling, and that's the lawyer part of it, but there are reasons for that, right? Because you can't test the reliability of things that are too long ago, and the law generally has a real distaste for old facts and old claims. And so a lot of the work I do has centered on Nazi era claims because that is unique in property claims, at least in American law, insofar as there are different limitations periods for those kinds of claims, particularly since the 2016 Holocaust Expropriated Art Recovery Act, an extension of which is currently under consideration before the US Congress. Other kinds of claims, as Tori said, related to colonial era provenance, or other kinds of cultural property, which I'm looking forward to hearing Kate's perspective on, chances are you're just not going to be able to proceed in court sort of out of the gates. And so the Nazi era claims have this interesting intersection of particular consideration under the law, which is a matter of policy and legislative expression, and frankly, a more voluminous documentary record. In addition to which, as you just were saying, Frances, sort of genres of painting that themselves are the subject of much more extensive study and documentation. And so just to sort of bring it to a close before we get into the discussion phase, like I said, I think of the catalogue raisonné as a very important part of the picture, where you can place a great deal of weight on what it tells you. But a catalogue raisonné is not a property register, right? It's not the registry of deeds. And it's important also not to treat it that way, because there are catalogues raisonné with mistakes. I mean, the Portrait of Wally case is the most famous one, where the Leopold catalogue raisonné from the 60s was simply incorrect. I think it was the 60s, forgive me. And conversely, other kinds of claims more recently, the Art Institute of Chicago case is an example. It's not a catalogue raisonné issue, but where without the ability to interrogate the witnesses who could say otherwise, the case has sort of turned everything on its head, and now is the disparagement of the art dealers involved in the 50s and 60s. And that, to me, makes no sense at all. So anytime you have this scholarly level of writing, the same way that any other peer-reviewed data in any other discipline, gets a certain kind of weight, it's a really important piece of the picture.
Yeah, I think that's a really good point. I mean, the catalogue raisonnés are not infallible, and there are numerous examples where, well, in fact, I mean, the kind of research that Tori's engaged in is actually aimed at correcting some of those errors. Will be maybe it not even kind of wittingly, but you'll come across errors as you go along. I assume.
Well, and I think just to make one final point, what I think of a catalogue raisonné, the way I try to remember it is, to me, its most fundamental purpose, at least in its origin as I understand it, right, is is the scholarship of linking the present to the creation of the object, however long ago that was, right? Because that in a time before databases was much harder to do. And that shows this is the Van Gogh that came from here and there and was painted by him or whatever, right? And there are lots of other kinds of data that can help with that now, but it provides that important link.
Yeah, absolutely. Thank you. Okay, so can we move on now to Kate? And perhaps you'd like to introduce yourself, Kate. Thank you.
Well, I'm really looking forward to learning a lot in this program. I think I already have, just from the introductions, because my background is very different. But I have to say, I find it very encouraging that Tori retains possession of all of the info on an object online, even after restitution. This is just key because cataloging art, as Nicholas pointed out also, is a continuing process. It really is never ending. We can never retire from what we do. And then to hear Nicholas's discussion about the importance of evidence and how that plays into this cataloging. With respect to what each of them said, I recently had the experience of speaking with the director of a museum of Native American art here in Santa Fe, who informed me that they were returning not only every single object from the ancient world that they had, the ancient American world that they had to current contemporary tribes, but they were also giving back all of the anthropological records that had been collected by researchers out in these areas, all the stories, because they were also considered somehow potentially invasive of these cultures. And I asked if they were keeping records of these, keeping copies, and she said no. So I think the kind of the opposite of what catalogue raisonné researchers do is book burning, and sometimes what is happening in repatriation is unfortunately going almost to that point. My understanding of how art and ideas circulate and percolate within society really comes from my study of Central Asia, which was for 4,000 years a place of transmission of ideas, transmission of art. So I suppose that I started on the path of law and art when I drove a VW bus from Amsterdam to Afghanistan with my boyfriend when I was 18. And we both fell very deeply in love with Afghanistan and its people, and our entire goal was to contrive some way of being able to stay there. So we started an antique textile business and eventually morphed into textile academics and specialists, writing books for museums on textiles and sometimes other aspects of Central Asian material culture. We also got to know both Russian and American archaeologists working in Afghanistan, and then later were able to work in Turkmenistan with Russian Soviet archaeologist Viktor Sarianidi at Goner Tepe at a Bronze Age site. But within 3 years of, not 4 years of arriving in Afghanistan, there were 3 coups d'etats and a Soviet invasion, and we moved to Pakistan with 3 or 4 million other Afghan refugees. Though I had no particular background in cultural heritage, after our work there was completed, I ended up being appointed to the Cultural Property Advisory Committee at the U.S. State Department by Bill Clinton. Faute de mieux. And that is the committee that makes recommendations on the U.S. law implementing the 1970 UNESCO Convention. So I had to make a very quick study of cultural heritage issues, and I was very fortunate to be mentored by John Henry Merriman at Stanford and James Fitzpatrick in Washington, both of whom were the experts in cultural property law at the time. And it appeared to me that the CPAC committee was implementing its own aggressively anti-trade and collecting agenda in ways that were at variance with the actual law and its much more modest intentions of finding a balance between public and archaeological and museum and trade interests. This concerned me, and I later worked with a nonprofit organization and organized a book on art law and cultural heritage and went to law school. Throughout this time, though, I had, while working in and out of Afghanistan and Pakistan and going to law school, I had really wonderful opportunities to catalog and write about various kinds of little-known ethnographic artworks and to help organize exhibitions. I'm much more of a cultural historian than a warp and woof person. This work of studying and writing the first more or less comprehensive books on little-known art forms of particular communities in Central Asia, that's as close as I've come to doing a catalogue raisonné, but it seems a pretty reasonable approach. It's just a historical and cultural approach to a body of work that does not have acknowledged authors. As a lawyer, I've been involved in representing collectors and dealers in Native American art as well as antiquities. I've done a lot of public education in and around that and helped to establish a completely voluntary repatriation program that has now returned over 600 truly sacred objects to Southwestern tribes coming back from tribal art dealers and collectors in the last 8 years. As our perceptions change, our way of dealing with the material changes as we learn. And I think the most important work that I've done is as editor and contributor to Cultural Property News for the last 10 years. It's a free, no firewall e-zine, culturalpropertynews.org, which covers news and policy and researches art law. There's some 500 articles now and a couple of dozen longer papers and publications. And some of these were done with the help of Trust Law, which is a philanthropic arm of the Thomson Reuters Foundation. So please visit our website and sign up for our free newsletter too. And I look forward to learning more through connections with all of you.
Sorry, turn myself off. Thank you. That was brilliant. So thank you so much for joining us today. I hope it's going to be an interesting discussion. Obviously, you will come from very overlapping backgrounds, which is interesting. And so I'm going to ask you a series of questions, just a few questions. And as I said, or as Sharon said at the beginning, please do feel free to put any additional questions in the chat, and hopefully they'll be scooped up by Emily. But I wanted to start with just this, because we advertised this as a session on looted art, and we realized straight away that actually the word looting is potentially kind of problematic. So I wanted to ask you each, do you find that looting is a useful term in relation to your work? And how would you characterize the different legal and practical problems related to spoliation claims and claims related to the repatriation of objects? So what's the kind of difference between the two? Those of us who work in museums will perhaps already, perhaps I'll start with Tori because he may have a direct answer to that.
Sure. I was trying to think about this question. I mean, I think looting is one of several terms that we tend to use when we are talking about art that has been stolen or taken without consent. We usually use the term looting when we're talking about the Nazi era or archaeological sites that have been plundered. But I think perhaps more important to me than the terminology that we use to denote theft in a museum setting is that, not to sound like a broken record about consistency, but I think that as a museum, we need to be consistent in how we are defining theft and how we address it. So for example, our collections policy says that we will not acquire anything known to have been stolen. That sounds, of course, obvious, right? But we're not going to acquire stolen art. But what do we really mean by that in practice? Because we have deaccessioned and returned objects that were taken from their owners in many different ways. There may have been, we've addressed, sort of straightforward thefts from museums. Last year, we returned to a museum in Sweden an Egyptian ceramic child's coffin that had been stolen in the 70s. I think nobody would argue that we had the right to hold on to that. We also addressed archaeological looting. We have returned artifacts to Italy, to Mali, to Turkey. We grapple with works of art that were taken during times of war. And most people think about wartime thefts. They think about World War II. But just a few weeks ago, we returned to Benin bronzes, or one of them was actually a terracotta that had been taken during a conflict in 1897. And then there are the objects that have been given or sold under duress. And again, you tend to think about Holocaust era transactions. But I think arguably many of the artifacts that are repatriated under NAGPRA, which is a federal law, were also taken without the consent of the tribes. That's the sort of thinking and the rationale behind how we define that they are in fact stolen. So not all of these are robberies or thefts in the sort of literal traditional sense. Many of these are de facto thefts, I would say, but still definable as stolen as we look at our collection. And some of our decisions to restitute were, of course, more rooted in the law than in ethics. Others were more rooted in ethics than the law. I think, we're a museum. We're a privately run educational nonprofit institution. So it is entirely reasonable for us to go beyond the letter of the law, both in how we build our collection and in how we make decisions about restitution. And I think, again, the important thing for us is to make sure that we're treating each area of our collection in a consistent way. We can't ask certain questions of, the curator of African art and then ask a series of completely different questions of the curator of ancient American art or European art. So I've sort of gotten off the topic of your original question, which is whether looting is a useful term. I think it signals a much broader sort of category of dispossession.
Yeah, okay, thank you. Someone's just actually written in the chat, how is the concept of taken under duress separated from works taken during nationalization policies, for example, in 1918 Russia? I don't know if you can speak to that or...
Sure. I mean, I think that nationalization is another kind of theft. It's when a government takes private property and makes it the government's. And we saw that certainly in the first half of the 20th century. But this is effectively what the Nazis did when they came in and they took Jewish-owned property and they made it the property of the state. And then after World War II, many post-war governments kept restituted artwork that either could not be immediately returned to an individual or were prevented from export. So I think we have seen this, over and over again throughout the course of the 20th century. And I would say those are also arguably thefts.
Yeah. Okay. Thank you. Great. Nick, how would you respond to what's the question?
I would echo
what we're saying.
Sorry. Yeah, I would echo what Tori said, which is that I think it is a useful term in broad strokes, and notwithstanding the fact that it is in the title of my book, it is not a term that I actually use that much anymore. Because in the work I do, those questions of terminology and those concepts have become increasingly more refined in a good way, I think. So to go back a couple steps, generally speaking, in American property law, which is pretty similar to British property law, at least, right? The exchange of property and the claim that it was improper puts the burden on the person complaining about the sequence of events. So if I take one of those books in Tori's office and I say, this was mine, she can take me to court. She bears the burden of proof to prove it's her book, and then she gets it back, right? In the Nazi era, that has developed in a lot of different categories, because in that particular historic episode, there are many instances of what we would colloquially call looting, where a government actor takes something by force. But there's a much broader group of transactions where someone didn't really have the ability to say no by virtue of their status under the National Socialist regime. And the Allies more or less codified that in administering Austria and Germany after the war to flip that presumption, to say, if you were Jewish or in a group of people that the Nazis were determined to eliminate from society, then we assume that the transaction you entered into was invalid because the circumstances compel it. And because the Nazis, as it happened, went to great lengths to pretend they were acquiring things that they were, of course, not actually paying fairly for, or people had the real choice to sell. And so in the modern era of attention on this issue, the first big step, of course, is the Washington Conference in 1998, which, again, to go to terminology, that's the Washington Conference on Holocaust-era Assets, more broadly. Mm-hmm. And it results in the Washington Conference Principles on Nazi Confiscated Art. Again, that kind of implies a governmental seizure. But what develops as these cases play out in practice are these other larger categories of folks who don't really have a choice. So it's one reason as I said, I think it's really important to be precise. And the law doesn't always have a good handle on how to handle those subcategories. So I'll give you a specific example. I represent the Allentown Art Museum in Allentown, Pennsylvania, which earlier this year sold at auction a painting by Lucas Cranach the Elder in his studio of a Saxon Duke, George the Bearded, great name. And this painting had belonged to a collector named Henry Bromberg, who fled Germany in 1938. Again, to what we were talking about in terms of documents, this wasn't a catalogue raisonné situation, but there was evidence of where the painting was at point A. There was evidence, obviously, that the family fled. Happily, they were able to do so safely. And then the painting appears in France, and then the painting appears in New York. But the appearance in France is before the Nazi occupation, and obviously New York is New York. And the museum found the moral story of the family compelling enough to enter into an agreement to resolve this claim, the specifics of which I can't say. But that's a category of what is increasingly called flight goods, right? Where someone may have sold something outside a territory occupied by Nazi Germany, but was there because of it. And so one of the articles I wrote last year was to try to think about how to deal with that, maybe under the law, under different standards that the law does recognize about when a transaction is unconscionable or the person doesn't really have the legal capacity to enter into it. Something that's more common for things like infirmity or legal capacity. But the law is continuing to try to find ways to categorize these things because in the broader sense of property law, stolen is a pretty specific thing. And a lot of these historic episodes don't really fit into that box. And so whether it is in reaching under ethical standards, what you deem to be a fair solution, or defending or claiming something under legal standards, how do we line those things up precisely?
Yeah, it's complicated. One of the things I was going to ask you about actually is how you deal when you've got several claimants, say, and you've got one object. How do you deal with that? I mean, I know you can sometimes have cash settlement, but very often it might be something which is, more kind of symbolic value. How do you kind of approach that kind of?
So that really varies, and at least the good news for me is these are my clients' decisions, not mine. If I'm on the claimant side, I mean, it creates practical difficulties, right? Because the more time goes on in subsequent generations, you have more people, and they're not necessarily aligned in the ordinary sense, and you can't split the baby unless they want to share, the object, in rotation. So that does often lead to approaches that have more to do with money, which can help in some cases. If there's any money to work with, it can kind of resolve things. It can make it harder if the current owner doesn't really have money to offer, but has a painting that is otherwise valuable. And it really has to do with what the claimants really want. Some claimants want what is the present day value of their ancestors' property, the same way that I hope whatever I have left when I'm done goes to my kids, right? It's property is property. And it's for them to decide what they want to do with it. Some want the unique object. And those disputes are often harder to resolve as a result. But that's one way it goes.
Yeah, I represent, well, I'm a trustee of the Burr collection in Glasgow, which has, I don't know if you know the collection, but it has, it's a very broad collection. It has ancient objects, it has some Islamic art, it has Chinese art, it has French Impressionist art. So there are all sorts of problems associated with it. But the main issue from a legal perspective is that it was bequeathed, and the terms of the will dictate that nothing can be, and this is a much more problem in the UK, that nothing can be given back from the collection, so nothing can be deaccessioned. So I mean, so I don't know if do you ever come across something like that?
I have come across that quite a bit in dealing with museums in Europe for just that reason. In the United States, there is typically a lot more flexibility because nearly all museums in the United States are private trusts or charities, and they are themselves subject to standards and oversight by attorneys general in the care of their charitable property. But they have a lot more autonomy about deciding what they want to do. But in terms of circumstances I've had where I was representing claimants dealing with European museums, that is often a big sticking point.
Yeah. Great, thank you. So I'm going to turn to Kate now, unless anyone has any comments they want to make about what Tori or what Nick said so far. We'll move on to Kate.
Well,
same question.
Yeah, which was, how do we deal with the terms looted or stolen, right?
Yeah.
My preference is to treat these as kind of dangerous words that should be used as narrowly as possible and as well defined as context as possible. I mean, if an object is taken in a war by the military or government and in a military action, that's looting, which before the late 19th century was actually considered normal behavior in war and was how most soldiers got paid, more than a pittance. Except in those particular situations, the definition, I think, of a looted object should be very narrow, limited to something taken illegally from an archaeological site, for example. That's a more traditional way of using that term. The term stolen is different. I mean, legally, under the U.S. Cultural Property Implementation Act, which is our only legislation that was actually directed towards international cultural property, an object is stolen if it's physically removed from the custody of a person or taken from a home or a church or an institution. That's how it's used in the legislation. Under the U.S. National Stolen Property Act, it's something completely different. Stolen can mean removed from the possession of a state, of a government, in violation of a law that makes that cultural property state-owned. Overall, I think today the terms looted and stolen are being used very inaccurately, and they are historically inaccurate and very misleading. While the term looted can rightly apply to illicit digs or thefts, using it as a blanket label oversimplifies the centuries of collecting practices, and it really undermines this whole concept of the universal value of cultural heritage. It can falsely at times equate restitution with justice, and it really assumes that all transfers of antiquities were exploitative or illegitimate. So rather than going into depth with that, I wanted to do something that I thought would actually be helpful, which is to introduce the audience to two recent books that offer correctives to this narrative. This one that I'm holding up, I know you can't really see it, is called The Antiquities Trade in Egypt, 1880 to 1930, the H.O. Lang Papers. And it's by Frederick Hagen and Kim Ryholt. And it really reveals how Egypt's antiquities trade was regulated and operated under official oversight. The Egyptian Museum itself, you may be surprised to learn, sold deaccessioned objects and ran archaeological digs to supply its gift shop, which was located inside the museum itself. And there are photographs, wonderful photographs in the book showing this sarcophagi and ceramics and other things in this museum gift shop that were excavated specifically to be sold to visitors. From the late 19th century until 1983, Egypt legally licensed antiquities dealers. And under the system of partage, additional objects left the country as a result of the division of the spoils of antiquities archaeological excavations. Another fascinating book that I just read is called Plunder with a question mark. And it's by Justin Jacobs, and it focuses on acquisitions from all over the world, but by museums and digging into their histories. It's particularly good in the whole China Silk Road section because that is his area of specialization. And what Jacobs argues is that today's claims of theft really rely on retroactive nationalist narratives rather than the laws and practices in place at the time. And this book has wonderful documentation of the actual transactions that I had never seen before. I think people also need to be aware that in many countries, including Iran and Turkey and Nepal and Syria, local elites and even like direct relatives of heads of government were some of the primary antiquities dealers. And so in these instances, we have to, there's a kind of disconnect between what we understand as the narrative of looting and the whole idea as to whether or not a government is actually either looking the other way or deliberately participating in looting actions itself. National ownership laws, I have to say, were very inconsistently enforced until well into the 20th century, long after many countries had signed the UNESCO Convention. And in some regions, they were simply not enforced at all. So I think that using looted as a catch-all term tends to erase these legal and historical realities. And it unfairly damages the reputation of collectors and institutions that acted responsibly at the time. And it deters scholarly research because it tends to keep things hidden rather than bringing them out into the open. And it can hinder museum exhibitions and block a really meaningful conversation about cultural heritage. I think with making good cultural policy, we need to start with some real facts. We also might give some thought as to who we are returning objects to. I have worked sometimes with an organization in New York called the Restitution Study Group, a group which strongly objects to returning objects to the Oba of Benin. The group is primarily a Black organization, and they are very cognizant of the fact that Benin was, at the time of that objects were taken in 1897, which is by no means the only time when objects were taken or exited Benin, that Benin was the largest slave trading state, and that these objects didn't belong to the people of Benin. The people of Benin had no access to these objects. These were strictly for the elite. And this group feels that the descendants of formerly enslaved peoples ought to have a right in determining the narrative that surrounds these objects. And a number of museums have responded very positively to this, and it has raised questions about returning objects to Benin, particularly because in April before last, the Nigerian government officially issued a decree stating that all returned Benin objects belong to the personal collection of the Oba of Benin, who is the lineal descendant of the same slave trading kings, not to the people of Nigeria. Raises interesting questions.
So Tori, just because I know you mentioned you returned to Benin or two objects to Benin. Do you have any kind of response to make to that at all? Did you have to go through
Yes,
this?
yes.
Yeah.
If anyone wants real drama, check out my LinkedIn page. What I would say, and I've said it before, is that we don't make moral judgments about claimants, and arguably a lot of people. We don't ask for sort of purity test, and the analogy that I've used before is that Nazi Germany perpetrated National Socialism and the Holocaust, but we still would return works of art that had been stolen from German national museums today because they were the victim of theft and they are the rightful owner. We don't go back and say, oh, well, but they were really doing terrible things at the time, so I think we should keep them. So we did restitute 2 objects to the Oba of Benin because it was from the Oba of Benin that they were taken in 1897. And not to take this too far, but many of the justifications for looting in 1897 were rooted in sort of moral indignation and a sense of cultural superiority. And I think it's dangerous to go down that road today.
Yeah, it's very problematic. So it's clearly not, this whole area is it's kind of fraught with major issues, major questions, and we have to be very careful. Is kind of the message that's coming across.
I mean, I think we do need to be, as I was saying before, we need to be consistent about when and how we remove things from our collection. And there are certain perhaps boxes that we want to check. Are we dealing with the right claimant? Is it the same object? Did a theft occur? What we don't do is say, oh, but did they really want it? Or are they going to take care of it? Or, like them? Is their government a nationalistic government? Or is it more of a democratic government? Like, those are interesting topics, and they're perhaps not completely irrelevant in the grand scheme of things, but they don't inform our decision to remove something from the collection and transfer title.
Okay, thank you. There's a question in the chat actually, which is for Nick. It said to return to the subject of Fluchtgut, when you mentioned the Pennsylvania Cranach case. The agreements between current owners and claimants usually remain unpublished, which makes it difficult to establish standards, which in turn can appear unfair from an ethical point of view. Are you aware of any statistics from your practice regarding agreements with Fluchtgut? Or is that,
so statistics, no. I think that's harder to track. I mean, so for one, one of the things I did in the paper I wrote last year in the Kansas Journal of Public Policy was try to track claims that you could characterize that way. So to go back over some of the cases I talked about in my book and some other things from other sources to sort of see how they had been handled. And some of the cases that were dismissed 10 or 15 years ago on statute of limitations grounds could be characterized as Fluchtgut cases, but the proceedings never got to that question. And so there's no decision point. There are, and as to other settlements, it's really up to the parties as to how much they want to talk about them, right? I mean, you will find obviously, the department that Tory oversees does a really incredible job of explaining when they reach an agreement what there is to say about it, right? And the museum that I worked for felt it really important to do the same. They did an exhibition about the painting, about a different painting they have that had belonged to the Rothschild family that was looted, but that had been restituted after the war, and so was returned to its rightful owner in the way these objects had followed different paths. And so, look, ethics is often in the eye of the beholder. I was very proud of the museum for the way they handled it. Their legal position was very strong, and I think they would easily have prevailed had they faced a claim in court. And they wanted to go in a different direction, and that didn't include an agreement whose terms are all public. But like I said, the painting was sold. So that's a fact. That's a public fact. And you can draw other conclusions from that are probably reasonable ones. And I think that the place where more information is available is actually from the European alternative resolution panels that came out of the Washington conference, because many or most of their decisions are at least publicized. And one thing I tried to do in the paper with at least a few of the commissions was to look at them and see sort of which of these things fell into that bucket. And some of those cases are themselves the ones that call out for compromise, right? You have, if you have a case where someone is clearly in exigent circumstances, and the law might not recognize a sale in Switzerland as invalid, is there some other way to recognize it and to resolve it? So that's a little what I tried to do in the paper. It's not as a statistical approach, because these resources are not really all in one place in terms of when someone reaches a settlement that never goes to court.
Okay, thank you. Oh, sorry. Okay, I've got, sorry, there's a little note from my team. Okay, so I have another question. We're moving on now to another question, which is in relation to transparency in your work. And this time I want you to think about it in relation to cataloging as well as restitution. So I might start with Tori, as we're going back to we want to bring the conversation back to cataloging if we can.
Yeah. And I would like to bring it back to provenance research, in fact.
Exactly, yeah.
I mean, yes, we do try to be transparent. And as Nick said, we try to be as transparent as possible when we do reach some kind of settlement or restitution and put that online. But where transparency, I think, is can be a real roadblock is in conducting provenance research. And that is because the art world has for so long really valued anonymity, and there are many good reasons for that. But before 1998, before the Washington Conference, there was not often a lot of provenance information or helpful provenance information that appeared in auction catalogs or appeared perhaps in catalogues raisonnés in the way that they would be today. And so, for example, one of the first works of art that I worked on here was a pair of altarpiece panels. And the MFA had bought them in the 1980s after they had come up at auction. They were sold anonymously. But I learned in my research that they belonged to a Jewish collector in 1938. Right. And then I also learned that these hadn't been returned to that Jewish collector immediately after the war, even though the rest of the collection had been restituted. It appeared on the list of works, one of the sort of post-war lists of works of art that were still missing. And it turned out that these two altarpiece panels had a very convoluted journey. They were misidentified at the Munich Central Collecting Point. The collection was misidentified. They were sent to the wrong country. They were sent back to the Netherlands and put on view in a museum in the hopes that someone could come forward. And they were eventually identified and returned to the family, but at a later date. And it was the family, in fact, that had consigned the two panels for sale when they came up at auction at Sotheby's. And of course, it is absolutely their right to remain anonymous, but I had to piece together all of these bits of information that had been either lost over time or erased or deliberately withheld. And I think, today that probably wouldn't happen at a major auction house, but I think it's sort of illustrative of many of the problems that provenance researchers can face, that while I can understand the need for confidentiality, it can hinder research.
Yeah, absolutely. Thank you. Kate, do you have anything to add to this notion of transparency? So you've got your muted.
I think Tori pointed to. Sorry, let me get rid of some of these windows that suddenly open when I press the wrong button. Tori was very wise in pointing to the importance of transparency and the importance of continuing the investigation into objects as far as you can go. And that's not just a matter of what documentation exists. It's an exhaustive process that looks at, where they came from and how they left the original owners, oftentimes hundreds of years, thousands of years, at least decades ago. And we often see that it's written that in the media that one of the big problems with the antiquities market is its lack of transparency. And it sounds like people are burning papers and stuff like that, hiding information. but in fact, it does have more to do with what she said about dealers not wanting to share their sources. There was no way to find out who was a prior owner, and it wasn't even considered a polite question to ask. There are also dealers, less scrupulous dealers, who represented objects that had been very long in circulation as fresh to the market because they could get a better sale price and more people interested in buying things than when they had been around for a long time, because it made it seem more exciting. I mean, today it's the exact opposite. Without a pre-1970 provenance, you basically can't sell most antiquities. I think, and the much bigger issue than transparency, as she noted as well, is the lack of documentation, which is unique to each transfer of each object. This is lost. And one of the main reasons it's lost is not because it was deliberately hidden. It was because you did not need additional paperwork to import antiquities into the United States or the UK. In the past, you could simply ship things in. When I was in Afghanistan, we had trouble sometimes shipping out carpets from Xinjiang, now China, but I think of as Eastern Turkestan, because they had cotton warps, and the Afghan customs would mistakenly associate them with the lower grade Pakistani carpets, and they didn't want the country of Afghanistan to be associated with these lower grade materials. There were rules. I mean, you had to, for any kind of antiques, you had to apply to the Kabul Museum for a permit, which was written by an archaeologist, not a flunky, and somebody who really understood the materials. In Afghanistan, at the time when I was there in the 70s and early 80s, you absolutely could not ship Buddhist materials outside of Afghanistan, particularly statuary, okay? But you could send early Islamic materials, which still circulated in the bazaar. People were still using things as pots and pans and braziers and materials like that. And you could also export Bronze Age material because nobody knew what it was. Nobody had any idea that it was 4,000 years old. It wasn't until I met Soviet archaeologist Victor Sarianidi that it was revealed, because there has simply been no information published as yet. When you brought things into the United States, you filled out your own forms, and U.S. Customs had no interest whatsoever in the paperwork from the Kabul Museum, which was written in Persian, handwritten on this thin airmail sort of paper, and stamped with a stamp you could have made with a potato. They just laughed and insisted that importers write their own accurate, dated, informational import materials. And after the 1979 Soviet invasion, the Afghan museum archaeologist actually told us that we should take whatever we had and leave with it, because it was better for us to have it than the Russians. I never worked in Egypt myself, but I think things seem to have been somewhat similar. I have seen shipments from before 1983 that simply identified materials as a box of antiquities. And while, long before that, the UNESCO convention had told signatory countries that they really ought to be setting up some sort of documented export regime in order to either retain or reject reject export of objects and retain them, or to permit export. And so far as I know, not a single country has done that, except Japan, which already had its own laws in place about regulating the export. So
thank you.
More research, more
research.
It's
so complicated. There are quite a few questions coming in, actually. So I'm just going to, there's one, I think this one's coming in response to what Tori's, I'm coming to you in a minute, Nick. As an American catalogue raisonné author, I was surprised to learn the European Data Privacy Protection Act does not allow me to publish provenance information that might make it possible to identify a current owner. This seems a step backward regarding current efforts to increase transparency. I mean, have you come across that, Tori? I mean, it is a problem, isn't it?
Yeah, it's not really a question, but a problem.
Yeah.
And I'm actually surprised by that. I didn't realize that it would go sort of that far. There are different privacy laws in Europe, and again, my experience with that is more on the research end of things. You can't just go and like look at someone's estate records or look at someone's will, even if it would be really important to your research. Which makes some sense, right? You don't want just like anyone coming in and like looking at, perhaps your grandparents' will. But if you're working on particularly Holocaust era assets, sometimes those documents are really key. So we've had situations where either I didn't have access to certain files, or I had to have our lawyers sort of like provide a letter of introduction for me to have access to certain files. But it remains an ongoing challenge.
Yeah. Thanks. And Nick, did you have something you'd like to say about what's kind of, how would you respond to that question about problems around transparency in your own work?
So what the question raises is a real issue, and it's getting harder because Kate published recently an article in her newsletter that's fantastic about the new EU cultural property import regulation, and these things are in direct conflict, right? So there is a standard by which you have to essentially establish the lawful export of the work from its country of origin. But as the question suggests, you may be prevented, or someone may have been prevented from providing the information that would allow you to do so. That's not great. I don't have a vote in Brussels, and I only get one vote here, but I think that's a real again, sort of in the most charitable sense, those are really across purposes of ostensibly the same objective. And I think it's going to be a real problem in the execution.
And thank you. Okay, I've got another question. Sorry, I'm being slightly distracted by the questions coming in the chat. So one more question, which is, I don't know, it is a question. Given the crucial role of publicly funded humanities institutions like NEH and IMLS in supporting archival access, provenance research, and the development of catalogue raisonnés, how do you see the ongoing defunding of these organisations impacting our ability to research for both catalogue raisonné and provenance-related inquiries? What do you all think may be the risks to the integrity of art historical scholarship and restitution efforts? I mean, Nick, maybe you could respond to that, because it must directly impact what you do.
I certainly don't think it's going to help. And look, it is a challenge, and the extent of public taxpayer support for cultural institutions in the United States is a long-running debate. I have my own opinions. Other people have their opinions, and it kind of hems and haws. It is clearly, at least in the first half of 2025, moving sharply in one direction. But June is not forever, and funding is always scarce for lots of things. And if it's dramatically more scarce, then a lot of these projects are going to be harder to fund. I mean, there is terrific private charitable support for these initiatives in the United States. And I hope that will continue. I think those resources will themselves be stretched a little more thinly. And so, sort of have to take it 1 month at a time.
What about you, the other two? Tori, maybe you would respond to that, because it may be something that affects you, or Kate.
It doesn't really directly affect me. And like Nick said, of course I have my own personal opinions. But in my work, I've not relied on grants from either of those sources. But I think it points to a larger discussion about funding, private funding. I think it's both a blessing and a curse. And I appreciate the freedom that we have as a private institution. We rely on donations from private individuals or other foundations. So I don't think it really affects my work, but you do need funding from somewhere to get this work done.
Okay.
In the 1990s, when I was working on a book on Central Asian textiles, a kindly professor that I was working with got me a Harvard Library card, And I felt so much smarter immediately. When I look at the defunding of not only museum services but library services recently, I mean, I'm just aghast. I think it's horrific, because I know that not only would I not ever have been able to get the one copy of a Russian book written in 1959 with the first 17 pages excised out with a razor blade, because Who You Could Thank had completely changed that year. From the Harvard Library, but I wouldn't have been able, as a resident of, say, Michigan, where that particular federal funding funded all of the interlibrary loans and was the sole reason why people in Michigan could borrow books from other libraries within Michigan, to say nothing of wider sources. I mean, I think this is potentially disastrous, but like Nick says, this is just June 2025, and we'll see what happens later. But I can't believe that. I mean, look at my background. What do we do without books? What did you do without access to, the information that, as historians, as curators, as legal researchers, that we have been collecting ourselves, and we know how hard it is to get that information, and how much we rely on the ability to access sources, because we're only as good as our sources.
Yeah, absolutely. And it is an interesting question in that a lot of academic institutions, I mean, in art history anyway, because I represent art history in the UK, and the catalogue raisonné probably is not a thing that people necessarily even think about, because they're sort of working in a different realm. So it is a problem. Just kind of connects with that. What practical advice this is for all three of you again, could you give to anyone engaged in putting together a collection catalogue like Tories, a database of, related to some body of work, or a catalogue raisonné of some sort? And I mean, maybe Kate, you could start actually, because you've sort of thought about this, haven't you, quite in relation to non-European art, which is always quite interesting.
Well, again, my perspective is really limited by the type of materials that I have worked with, the type of objects, and the type of research I've done. But for me, I mean, bottom line, any kind of cataloger should be, in some sense, like a cultural historian, not just a compiler. And I think that because our backgrounds so much influence our perspective on different types of art and periods of art and communities that produced art, it's an incredible luxury to be able to take that time. But I still think that that's something that we all want to, we all strive for as historians or as catalogers. And that story for ancient art and for ethnographic art doesn't just begin in an artist's studio and then have the first step be the sale from it. It has to do with the object's life in its original context, not its path through the art market. So it's a much broader question and a harder question to answer. So, what role did this object play in the daily life of the people who created it, in their ritual, in their governance, in trade? Were they used communally or privately? Were they commissioned or inherited? Were they mass produced, as so many types of antiquities that are restricted today were actually made in the millions, sometimes the billions, as in coins? How did they circulate? And how did they influence other forms of art in other places? So I look to ethnographic sources and oral histories and indigenous scholarship, as well as foreign scholarship, wherever possible. And I try to go beyond just labels to function and meaning. But my work is very different from someone who is working with a very well-known, sort of well-understood body of work like Renaissance paintings. There's still a million things to find out, but it's already some background. The work I have done in some cases has been basically starting from scratch, doing the first book on a particular type of object. So I have to go a lot deeper.
Yeah, okay, thank you. Tori, you might have similar or different views, and also you've got a kind of broader spectrum to deal with, I assume.
Yes, so devising a cataloging standard for 7 different curatorial departments is not always easy. But actually, I wanted to go back to something that Kate said just a few minutes ago, which is that we're only as good as our sources. And I think that's really important to keep in mind because we try to be as thorough as possible. But of course, new information can come to light at any time. Research is an evolving practice, and information is often imperfect. It's often incomplete. And so when I write my provenance texts, if something is uncertain or if it's unclear, I think it's important to explain why the uncertainty, why is there a question mark after this? What is the confusion? And so I'm a big fan of the provenance footnote. So we have like the sort of cut and dried ownership history, but then, maybe we do need to explain where did this information come from? And I think that's one of the most important things that I try to impart on my interns is just not just what is the provenance information we have, but how do you know that it's true? Like, have you followed the footnote? Because there's human error as well. I mean, there is provenance that has been falsified, right, to cover up instances of looting or forgery. But we need to correct the art historical record whenever there's a mistake for whatever reason. And I think as Kate was saying, where something was excavated matters. How altarpieces were broken up and dispersed matters for us as art historians. So I think just being sort of as transparent as possible about not just our information, but our sources as well is for me, the most important thing.
Yeah, that's really interesting. And this whole thing about, I think people don't understand that objects can arrive with false provenance. I mean, it's very common, isn't it? And,
Yes.
especially historically.
Yeah.
I don't know whether it still happens today so much, but
Sure. Or, we might receive something in a bequest that was cataloged 20 or 30 years ago. And sometimes it's just a mistaken memory. Sometimes, one object has gotten confused with another. In other cases, there is deliberate falsification. But all of these mistakes need to be corrected.
Nick, what about you? Any advice?
So what I would say as a lawyer, but this is, I think, the advice I would give to anyone writing, is just imagine someone is going to read it who is not inclined to take your word for it, and think about how you are presenting what you believe that you know. And I think the clearer that any source is about what you're able to know is part of the contribution. These inquiries often have dead ends, and you may find something that's attributed to source X and explain that that's the source, and you have no reason to disbelieve that source, but you can't confirm it. And it may well be later that somebody is furthering the research and they have access to something else that proves that that source is either unreliable or reliable or something else. But if you hadn't shown your work, essentially, then the later person can't benefit from it. And because I think those things that don't stand up to scrutiny, are obvious, right? I mean, to set the Leopold example again, right? If anybody had asked Leah Bondi, she would have dispelled the provenance forthwith. And that's an extreme example, but like I said, just sort of not to be cynical, but imagine a reader who is, if not incredulous, not necessarily overly credulous.
Yeah. Oh, well, I think it's very important to be cynical at all times. It's true. So what I mean, we're dealing with an artist like you mentioned Van Gogh earlier. There are, of course, all these different catalogue raisonnés, and that's one of the other things that I think I would say to a scholar or to anybody who's kind of looking into provenance. Make sure you've got the most up-to-date version, because it changes all the time. So it's I think this came up right at the beginning, that it is unreliable. Catalogue raisonné is unreliable, but we're doing our best to sort of improve. And but it's kind of an ongoing process, isn't it?
Well, and I think I am a huge believer in connoisseurship, not as a definitive thing on everything, but in the modern age, I think there's a tendency to disfavor it in this pursuit of more scientific outcomes. And it doesn't have to be all of the other, and I think it shouldn't be all of the other. But all the more reason, if you're on the connoisseurship and scholarship side of things, to be so scrupulously careful, because if you're not, then it really knocks the legs out of using that kind of information, which is very valuable.
Yeah, absolutely. So we've got about 10 minutes left, say, or 9, or maybe not. I wondered if there are any other. Oh, here's a quick question. What do you do when an art dealer doesn't want to be mentioned in selling a piece? That is one question. And second question, do dead people still benefit from privacy? So what does that mean? I'm not quite sure. Are you allowed to mention them as an owner because they have? Are you allowed to mention them? So once they die, does the privacy cease to be an issue? I mean, I think we've sort of covered that before with if a private owner. So someone's talking about a private owner who presumably still living, but once someone's died, do they lose that privacy status? I think is the question. And yeah, so can an art dealer choose to be anonymous? Not so often usually, but I mean, perhaps this is a legal and it's a practical question. Victoria, have you got a response?
Yeah, I mean, I think it probably varies from museum to museum. We do not allow sellers to remain anonymous. That might have been something that we did in the past. We will honor requests for anonymity with donations, but not for sellers. And once that anonymity agreement is in place, it really stays in place. So, regardless of whether someone has passed away, we would need, written permission from perhaps their, descendants or whoever represents their estate, to de-anonymize them. We have de-anonymized people. I'm not sure that's a real word, only in certain cases.
Okay, thank you. Nick, do you have something to say to that?
I wouldn't really add much to that. Yeah, I mean, really, the extent to which someone's agreed to honor anonymity is an agreement, and it depends on what you've agreed to.
Yeah.
Death of the person doesn't change that necessarily.
I mean, you find private owner, don't you, all the time in catalogue, isn't it? It's a thing, isn't it? Kate, have you come across anything like that?
Well, recently I was looking into a return of a very large collection of archaeological materials collected by and donated by people who were identified in belonging to Colgate University. And when I contacted the university to see if if that name belonged to someone who I had identified as potentially a big philanthropist who had worked in Mexico, and the university wouldn't even tell me if the person was the same person, citing privacy concerns. And I was, puzzled in part because partially the information was there, and I just wanted to know if it was the same person that I had identified, but they wouldn't tell me, and so I do run into it.
Yeah,
but I think, I understand why museums feel that they need to respect these rules and things that they contractually signed on to in the past. But I think that in order to make sure that legislature can work to the benefit of the public, that we need then to acknowledge that these limitations exist and try and find ways around them so that we don't just block access to information and access to objects. I think access is the most important thing that museums offer to the public, whether it's access to objects, access to the history of their own peoples, or access to a better understanding of the world around us, which art is possibly the best way to reach that in a non-confrontational way and in a very personal way.
Thank you. Tori, did you want to?
I'm just thinking because it's really tough, because I'm in a position sometimes where I do have to honor anonymity, but at the same time, I'm like transparency. So sometimes our hands are really tied. And for example, with works of art that are on the market, very often dealers do not want to we'll give the name of the dealer, but the dealer doesn't want to disclose who they got it from for various reasons. And I do get that. But if we're acquiring archaeological material, we can't just rely on the word of the dealer here. So there have been times when we say, could we be in touch with the original owner, or can you disclose this name? And we will keep that confidential, but internally we need to be able to review and verify it. So there's sort of like differing levels of anonymity and confidentiality, but I see both sides of this.
Yeah, thank you. I'm going to hand back to Sharon, but I just want to thank you, all three of you, for a really fascinating discussion, really stimulating. And I think I mean, one of the things that's come across is just how tricky the whole question is, and we just have to be very, very careful and kind of diligent about and transparent about the way we act. So thank you very much, and I'll hand back to Sharon.
Yes, thank you all so much. And yes, we are only as good as our sources. I think that's my biggest takeaway from this last hour and a half. It's wonderful that we remember that. Hope to see everybody again on a future Zoom. And thank you to Kate, Tori, and Nick, and the wonderful Frances. Very, very interesting. If you have other questions for them, feel free to write us at ICRA and we will forward them to our speakers. Have a good evening.